So in the situation where we do have a no-deal Brexit, there will be some significant impacts on businesses that process and transfer data in particular between jurisdictions, being the UK and the rest of the EU. If you are in the UK and you are processing data about EU citizens, you're going to have to think about multiple legal regimes. So you're going to have to comply with the regulation in the UK, but you'll also potentially have to comply with regulations in the EU, and that might mean things like putting in place a representative in the EU to make sure that where data subjects, individuals whose data you're processing in the EU have an issue, that they can go to your representative and go to the regulator in that country. So if you are in the UK and nowhere else, but you're using personal data or you're selling goods and services to consumers in the EU, you're going to have to think about that representative and that additional jurisdiction. But for those organisations that are both in the UK and in the EU, and potentially are transferring data amongst your group companies or with service providers or other partners within the EU and the UK, we're going to have to start thinking about international transfers of data. Now, up until now, that's not been an issue. So international transfers are free across the EU between all member state countries. When the UK leaves the EU, then it will become a third country in EU parlance, and that means that basically we're not trusted. It means that until the EU makes a formal decision that it considers that any data protection in the UK is adequate, you might have heard people talking about an adequacy decision, then there will be restrictions on any transfers of data from EU member states to the UK. Transfers of data from the UK to the EU or to any other country will not change. The UK government has said that it will be exactly the same regime as it is now for data that's leaving the UK. But you're going to have to think about any data that's coming into you from EU member states and how you manage to protect that data. Because as a starting point, any transfers of data from the EU to the UK will be unlawful. So there needs to be a safeguard put in place to make sure that that transfer becomes legal and that you can continue to carry out your business in the normal and seamless way that you will have done to date. When you're looking to make sure that your transfers are legal, there are a number of routes that you can take. The first is leave it to the government. Let's get an adequacy decision that covers the UK. The reality in a no-deal situation is that that's not going to happen immediately. It's going to take a period of time, likely to be at least a couple of years, before the UK can convince the EU that it has adequate protection for data. And there's no guarantee, even in that situation, that the EU will grant us that adequacy decision. There are a number of issues that the EU might have with the way in which our government talks about data and processes data, which weren't an issue when we were part of the EU, but might be when we're a third country. Alternatively, the government might come up with another arrangement between it and the EU, along the lines of the arrangement we have in place at the moment with the US for Safe Harbour or for Privacy Shield. That covers the transfer of data, and it's possible that might happen. But again, in a no-deal situation, that's not going to happen immediately. So what can you do now? Well, looking at those data transfers is the first stage. So understanding what transfers you have that are happening from Europe into the UK is your first port of call. If you have lots of data transfers that are happening, for example, from customers in the EU that are transferring data to you as a service provider here in the UK, you could look at something like standard contractual clauses. These are contracts that have been agreed by the European Commission as being appropriate for safeguarding data transfers from the EU to countries that don't have an adequate level of protection for personal data. Things get a little bit more difficult if, instead of having a customer who would be a controller of their data in the EU transferring to you, instead it's a processor that's in the EU that's transferring to you, because technically there are no standard contractual clauses which are going to apply in that situation. The reality is that this is the case anyway for any processor in the EU that's transferring data to anywhere in the world other than other EU countries, but it's the first time UK businesses have had to think about it. And so if you're using service providers, for example, data centres in Ireland would be a really good examples of this, understanding whether or not there's going to be any change or any delay in getting a transfer of that data between your service provider and you will be really important. The final method that you could use is something called binding corporate rules. That's something that a lot of international businesses look at, and it's basically an internal set of policies that are approved by the regulators as providing an appropriate safeguard for your data. The issue in a no-deal Brexit situation, though, is again the timing. So getting approval for binding corporate rules is not a short and simple matter, and it's something that would take a number of years. So that's maybe one to put on the back burner for the future, but probably not something that's going to help you in the immediate short term. So we talked just then about the difference between transfers of data when you're a controller and when you're a processor. Controllers are organisations who decide how the data is going to be processed and why. So for example, you would be a data controller in respect of your employees' personal data, because you are deciding how and when that personal data is going to be processed. If, on the other hand, you're instead providing a service for a third party, or you're only processing personal data because they have asked you to, and you're acting only on their instructions, processing on their behalf, then you'd be a data processor. And it's in those circumstances where you're a processor in the EU that you don't have a good set of standard contractual clauses which would allow that international transfer. So organisations that do have a pan-European business, it's also really important to remember that, as I say, you're going to have to look at 2 different jurisdictions worth of personal data regulation. The laws that we have here in the UK, which will be almost identical to the laws which apply in the EU. So your compliance might not be that difficult, but it's really important to remember that you're going to have different regulators that will apply. At the moment, the ICO can act as a one-stop shop for any complaints in relation to the processing of personal data cross-border. But once the UK leaves the EU, the ICO will not be a part of that framework of regulators. And so additional regulators in the EU could all call you out for any issues. And it means that you could be facing multiple forms of regulatory action. It's a really confusing area for businesses to try and work their way around. But it is something that there's a lot of information out there about.
So I work at the binding site here in Birmingham. We are a medical diagnostic company and we diagnose and monitor any kind of blood cancer and other immunological disorders. We are headquartered in Birmingham with around 750 staff in the UK and a further 300 worldwide. So we have various countries that we serve across the world, around 50 countries that we export to, and that's serviced via a range of subsidiaries and a network of distributors. So Brexit absolutely will impact on us as a business. A large proportion of our customers are in the EU, and so we've had to prepare for the worst, if you like, by assuming that it will be a no-deal Brexit and work our mitigations around that. So to prepare for Brexit, we set up some committees. We pulled together key stakeholders in the business who would be impacted, so logistics, regulatory, finance, and our subsidiaries. We all played a key role in coming together to look at what might be impacted and to assume the worst, really. We wanted to make sure nothing comes as a surprise and to make sure there's a cohesive approach to Brexit preparations. We started that a long time ago. It's something that's been on the horizon, and we didn't want to let any opportunity slip, because we were also hoping to see Brexit as an opportunity to show customers a seamless approach to Brexit and to be a prepared business. And we've done that by regular communications, regular talks and updates to our customers and our suppliers, and pulling together all the key people, making sure they're doing their role in preparations. So we have applied for authorised economic operator status to ensure we can show that the supply chain is secure and to help us in our customs movements there. That's ongoing. We've got a lot of employees from the EU working in the UK and likewise vice versa, and so it's been a real key communications exercise for us to ensure that staff feel secure, that we're supporting them in their applications for settled status, and also to ensure that we retain and continue to attract the quality of staff that we need. So that's been a separate exercise of its own. We've made sure that we've increased stock holding across Europe, increased capacity greatly so that we can continue to seamlessly supply customers there. And we've also worked with suppliers to make sure we've built up our raw materials so that there shouldn't be any kind of issue on that front. Then separately, we've an ongoing exercise. We've been preparing for Brexit through data protection mitigations, which has been an exercise ongoing really as if it was the anniversary of GDPR back in May, just a review exercise almost. So there's been a lot of activity in preparing for data protection changes. So we've, again, as I said, we've assumed it will be a no-deal Brexit because that should really mean that the UK will be a third country and that no data can transfer from the EEA into the UK unless we put measures in place. So we've looked at those measures, and for our business, assuming that standard contractual clauses will allow us to continue transferring the data. Those standard contractual clauses are being put in place with all key suppliers, subsidiaries, customers. Wherever we have data flowing into the UK from the EU or the EEA, we have got in touch to start negotiating those clauses and making sure that everyone's comfortable with those arrangements. I have to say, the ICO, the Information Commissioner here in the UK, has produced a lot of information on that, which has been really, really helpful. There's on the website, I'd recommend anybody to have a look on that and just search SCC, Standard Contractual Clauses, and there's a range of boilerplate documents which you just enter your requirements into, and it churns within about 5 minutes. You've got your ready document to send over to your third party, whether it's a customer or a supplier. So that's been a great help to us. It has been an extra burden, I have to say, an extra lot of work, and perhaps a lot of people will see it as a distraction from the day-to-day operations. But realistically, the impact of getting it wrong and not being proactive with GDPR could be catastrophic for a business. The fines from the regulator alone could be massive, but also just the opportunity to communicate to customers, suppliers, that we are being proactive with their personal data and reassure them that we take that very seriously. It's got a good reputational stance for us. Touched on it already, but in terms of a top tip, communication and also preparedness. So communication wise, we've put out lots of customer summaries of what we've been doing and suppliers, which has really helped to avoid having too many questionnaires. I know that many companies are sending around Brexit questionnaires at the moment, and they can be really time consuming. So having a short summary of all the activities and reassuring people that we're on top of it as much as we can be has been a great help. And then also preparation. I think GDPR is perhaps not the forefront of everybody's mind when we're facing such unknown times, but it can be, we've treated it as an opportunity to just review what we did last year, putting in place our GDPR measures and making sure that they work, making sure our policies are effective, as an opportunity to be back in touch with customers and let them know what we're up to. So it's a challenge, but it's not overly time consuming once you've got your head around the ICO's guidance, and it's a good opportunity to get your ship in order really.
The Information Commissioner's Office have published a number of notes for organisations that do need to think about data transfers post-Brexit, and they set out in those notes in what circumstances might you need, for example, an EU representative, but also how to deal with those data transfers. So I'd highly recommend having a look there.